Hey folks, Dale Davidson here, the Dear VA Guy. Thank you for tuning in today. So the question is, your rating decision you got was not what to your liking. Maybe you were denied, maybe your disability rating was low, too low. What you gonna do about it, okay? So in these cases, you basically have three options for trying to change your rating decision. Option 1, request a higher level of review. Option 2, file a supplemental claim with new and relevant evidence. Or number 3, file a notice of disagreement to appeal the decision directly to the board. Now you can choose different review options: higher level review, supplemental claim, notice of disagreement. So you can choose different options, we call them lanes, okay, for different issues adjudicated within the rating decision. Kind of like driving on the interstate. You see some people in the same, in your lane, their lane, but you can do this for the VA. Let me give you an example of this. So the VA denies entitlement to service connection for your knee and PTSD. Now you can appeal the knee to the BVA, the Board of Veteran Appeals, with a supplemental claim, okay, while seeking a higher level of review for the PTSD issue, okay. So you see you're on two different tracks, okay. However, if you're granted entitlement to service connected for your lower back, okay, but disagreed with both the effective date and the disability rating, you would need to choose the same review option, meaning higher level review or supplemental claim. Just be careful as to what you choose. Now, what do you not have the right to review? You don't have the right to review a VA decision of denial by a decision review officer. You don't have the right to review, or you don't have the right to a hearing before the VA. You don't have the right for a statement of the case, and you don't have the right to submit new and material evidence within the year of the rating decision and automatically get a new rating decision that addresses the newly submitted evidence. Be careful on the do's and don'ts of what you don't have the right to do. Hint, maybe you're better using a supplemental claim option to get around these issues, because with a supplemental claim you can submit new material evidence. Higher level review, you cannot submit new evidence, okay? So you received a decision which you didn't like, so now you're on the clock. The decision deadline for taking one of these actions, one of those three actions, is 1 year from the date of the notice, a decision, okay? So if you file one of these within the year, you've preserved the effective date of your claim, and your claim is considered to be continuously pursued, okay? So your effective date of the claim that was denied is still the date that you filed the claim. So what does continuously pursue mean? I mean, keep the claim alive, okay? It's important that you keep the claim alive as best you can. We oftentimes here, we don't have that luxury because the claim is more than 1 year old. But how do you keep a claim alive? Well, you file a higher level of review, a request for higher level review. You file a supplemental claim. That's where you get to submit additional evidence, okay? Or you file that notice of disagreement and appeal directly to the Board of Veterans Appeals. So if you didn't meet the deadline, that 1 year deadline, all is not lost. You can still file with the VA at any time in the future a supplemental claim identifying new and relevant evidence. If the VA grants the supplemental claim, the effective date assigned will usually be the date that the VA received this supplemental claim. You don't get to go back. So you see how the importance of continuously pursuing your claim is you have preserved that earlier effective date. If you miss that effective date, you're going to get a new effective date with any kind of higher level of review, or supplemental claim. You can also file at any time a claim for revision, not reopening, of the final decision based upon clear and unmistakable error, which we went into in detail in a different video. Now let's talk about more in depth about the higher level review. In the legal world, we call this a de novo review. That means that it's brand new. All the evidence in your file goes to a more experienced claim examiner who didn't participate in the original decision, not supposed to know anything about the original decision, for that claims examiner to review everything and see if they would come up with a different result. So again, they're not supposed to consider anything regarding the prior decision except for favorable findings. For instance, service connection. We find that you're service connected. They say, okay, we'll take that at face value. All right, so that's a good thing. So the reviewer can't give any weight to any negative aspects of the prior decision on review or the fact that the claim was even denied. Now, look, they know the claim was denied because they've got it on appeal. So they're going to know that, but they're not supposed to take that into consideration. So this higher level claim examiner is going to grant the claim if he or she determines that the evidence that's already in the file satisfies the requirement for the requested benefit. Again, no new evidence. No new evidence. But you can still give legal argument. The reviewer can grant the claim based upon a difference of opinion. Maybe they said, well, the previous adjudicator saw it this way. I see it a different way. And so I'm going to rule in your favor. Okay? Again, if you've already got the benefit in the prior decision, they can't take it away from you in the higher level of review. They can agree with the negative part of the previous decision, but they can't take any of the positives away from you. I just want to make this clear. Whoever's the higher level reviewer is, they can't revise the prior decision in a manner that's less favorable to you based upon a difference of opinion. So again, I'm just going to take service connected. They can't say, well, I know the prior guy said, or lady said, hey, it's service connected. I don't agree with that. You've already got that favorable decision there. They can't change that. Now, the reviewer can reverse or revise decision on review based upon a finding of, again, we've talked about clear and unmistakable error, even if the reversal is disadvantageous to you. So you've got to have your facts straight. You got to have your legal argument on point. The reviewer can also return the claim to the VA if the reviewer says, well, the VA did not comply with its duty to assist. And we talked about that in a previous video also. So duty to assist is very important. So the reviewer can only consider what's in the record at the time the notice of decision is being reviewed. Only what's in the record then. Again, no new evidence. Okay? So you or whoever your representative may submit argument regarding the error contained in the decision. You can go through your C file and point out, and they say, well, they said I didn't have any kind of injury in the service for my left knee. Here, look in my medical records on page whatever it is of my C file that you have, and clearly it shows that I had an injury. So they missed it. VA, they missed it. You can make those kinds of arguments and point out their errors, but you can't provide additional evidence. Of course, I'm a lawyer, so in my opinion, your argument needs to be written and submitted along with the request for higher level review to ensure that that individual considers your argument before issuing a decision. Again, I like to present written legal arguments. I like to cite the statutes. I like to cite decisions, the court decisions that are favorable to my client's position. That gives the reviewer the chance to think. It says, maybe this lower level reviewer really didn't take into consideration everything. That's why I'm a more sophisticated, higher paid reviewer for the VA. So therefore, I'm going to, I like that legal argument, and so I agree with it, and I'm going to go ahead and issue my decision favorable to you. So again, very important to have I'm a big proponent of a legal argument. So how do you request a higher level review? Well, to request this kind of review, you gotta, within a year, okay, of the decision, you gotta file on their specific form. It's a form 200996, and you gotta list the date of the underlying decision and specify the issues to which you are looking to review. Now, you can have an informal conference with the VA. I've done that before. That takes longer than just letting them take the file and look at it. So who conducts the higher level review? Well, more experienced adjudicators. So people who have come up through the ranks as, adjudicators, and they've gotten experience and they've been promoted, and so they know more about the law and about how the VA rules and regulations are supposed to work. Now, remember, higher level reviewer can only consider the evidence that was in the record at the time of the issued decision that's being reviewed. But they can always consider your legal argument. So we've talked about no new evidence, okay? But you do have you do have a right to the legal argument, okay? You don't have a right to a hearing, okay? But you can request a informal conference, okay? Now, I've had clients submit evidence to the VA after or with their higher level review, and the VA writes them back, says, thank you for the additional evidence, but we didn't consider it. Here's our decision. Okay, so you're wasting your time if you are sending them additional evidence, because they're not going to look at it. So if you are VA healthcare, or you're receiving VA healthcare, make sure that everybody in the loop has up-to-date medical records on you. That includes the higher level reviewer. Just provide them, okay? Trust me on that one. So what is the VA's duty to assist in a higher level of review? It doesn't exist, okay? They don't have the duty to assist you in the higher level of review. However, if the higher level reviewer discovers that the VA committed an error with respect to its duty to assist you before the decision was rendered, before, not after, okay, the higher level reviewer must return the claim to the VA for correction of that error. However, the VA examiner has the power to grant maximum benefits based upon the evidence of the record. You may have a duty to assist error, but the VA adjudicator or the reviewer can say, well, based upon the record, Dale's now at 100%, and game over, okay? So the maximum benefit in the record, okay, remember, it's what's in the record. It's not anything new. So how do you choose? What option do you choose when trying to change an unfavorable decision? Do you do a higher level of review? Do you do a supplemental claim? Do you do a notice of decision? There's really no answer that is totally right or totally wrong. So I can tell you from my experience, since 1992, I can tell you that this is how I approach it. I always try to determine which option is most likely to result in a favorable decision in the shortest amount of time. I want you to get your benefit quickly, and I want you to get the maximum benefit. Okay? So what I do is I first identify why was your claim originally denied? Of course, that's reading the decision itself and looking at all of the evidence that the VA, meaning they, reviewed and considered in making that decision. And then what is necessary to remedy that denial? Does it mean searching through all your C file and looking at your medical records to make sure that the VA picked up on your knee strains or your knee problems or whatever it was during service? What's it going to take to find out, how can we remedy this? Because if we've got things that are in your C file that the VA missed, we'll bring that to their attention. So higher level review may be a good option for trying to change an unfavorable rating decision when some of the following factors are present. There's no more new evidence to give. I'm resting on what's in my file. So maybe the VA committed a duty to assist error. In that case, the VA hearing officer, the higher level review officer, would either kick it back to the VA to correct that or could award higher benefits, the maximum benefit. Okay? Maybe the rating decision contained an error of fact. For example, the rating decision erroneously stated that I didn't injure my knee in service. But again, service treatment records show that clearly, but that was just overlooked by the adjudicator. That's actually happened to one of my clients. So maybe the rating decision contained an error of law. For example, the rating decision erroneously stated that the presumptive herbicide exposure does not apply to your service in Guam in the 1970s. That's not what the law says. Okay? So that's an error. Okay? That's the VA applying the law incorrectly. Okay? Maybe there's evidence that's for and against the claim are approximately balanced or nearly equal. And one adjudicator says, I'm going to give more weight to this versus that. So what do? In this case, this is where the legal argument comes in. You get the benefit of the doubt. They call it equipoise. The evidence is nearly equal, so you get the benefit of the doubt. Tie goes to the runner, you win. But the first adjudicator said, nope, even though this evidence is pretty well equal, I'm going to give more deference to this. Okay, that's a possibility. Maybe the case involves specific complicated issues of fact and law that a more experienced adjudicator may be able to better understand than the lower adjudicator. For instance, maybe we have a claim for PTSD, and maybe the unexperienced adjudicator didn't realize that there are specific ways to go about diagnosing PTSD, and that you can't just use a benefits questionnaire to diagnose PTSD, and that the PTSD's got to be diagnosed by a psychiatrist or a psychologist, not a PA. The experienced adjudicator would pick up on that, okay? Not necessarily the inexperienced one. And again, you might want to do the higher level review because you get a quicker decision. However, realize that higher level reviews are not a good option if you need additional evidence that the VA needs to see. Again, because a higher level review won't allow new evidence in, allows legal argument, where the supplemental claim allows in new evidence. Additionally, if you want a hearing, don't elect a higher level review, as you don't get the opportunity, for a hearing. Now, for a supplemental claim, you or your witnesses can testify, but again, you don't get that opportunity with a higher level review. All right, thank you so much for tuning in today to talk about the higher level review. Hey, check out this video. Does the VA really want to help you? That will, again, give you some insight into higher level reviews and their duty to assist. So until next time, have a blessed day.